Thank you all for being here. Thank you to the law review editors for the invitation, but I really do want to thank you for being here. When I was a student here, I think to get a crowd like this at 4 o'clock on a Friday, we would have had to hold the event at the Barking Spider. And, you know, as John mentioned, I'm an alumnus. I'm also from Cleveland, and so I've been having waves of nostalgia since coming in last night. And I've been struck really by two platitudes. One is you can't go home again because nothing is the same as when I was here before. My whole family has moved away, so I had to stay at the hotel like everyone else who's not from here last night. And then coming to the law school, not one of the 8 professors I had in my first year still teaches here. So it's a very different institution. I found out to my never-ending chagrin at dinner last night that you no longer play the law review moot court football game. This is terrible. It's not the same institution. The other thing I've been struck, the other platitude that struck me is that home is where the heart is. And despite all the changes from the time I left, my heart is still here, and it's still here in no small part because John is still here, who is a great teacher, and you will carry that, him and your other great teachers, with you through your legal careers and whatever it is you end up doing. So I want to thank John not just for being a great teacher, but for being a great mentor and for many kindnesses and much generosity from the years in between. Go ahead, he deserves it. But you didn't invite me here to reminisce, so I will put that aside and try to earn my supper, which was very good last night. Thank you for that. And I want to talk about the topic for this panel, which I'm really interested in, and that is Baker's legacy for the institutions, and especially the institution of the court, but the other branches as well. But I'd like to talk about it, if you will indulge me, outside the box of reapportionment. So I want first, to me, the most interesting opinion in Baker is Justice Frankfurter's dissent, right, which reprises his warning from Colgrove versus Green about the court getting into the political thicket, his warning that getting into these cases was inappropriate for the judicial role. I think the relevant precedent, though, for really considering Baker isn't Colgrove versus Green or any of the other reapportionment cases. It's one that will be familiar to all the students in the room, unless you're first years, Erie Railroad versus Tompkins, right? Because in Erie, the court articulated a restrained view of the judicial role, right? That's what Erie is all about, is the judiciary won't be in the business of making law anymore. It should have a very constrained role. It shouldn't be out there doing that kind of thing. Baker is itself not primarily about election law, right? It's primarily about the political questions doctrine and the division of power between the court on the one hand and the political branches on the other. And so really Baker, like any other political questions case, concerns separation of powers rather than reapportionment or election law. And the reason I say that Erie then is the relevant context is its view of the judicial role within the separation of powers. Now, Justice Frankfurter was, of course, a leading champion of the Erie decision, right, and wrote some of Erie's most important progeny. And it's, I think, not at all a coincidence that in his dissent in Baker versus Carr, he quotes the brooding omnipresence language that he had used in one of the Erie cases, Reagan versus Merchant Warehouse, because to him, it's the same issue. Right? This case actually turns out to be Justice Frankfurter's swan song. It's the second to last opinion he wrote, and it's the last major opinion that he wrote. And it's a warning to the court to adhere to the role that was articulated in Erie and not go down the road that Justice Brennan is articulating for the majority in this case. Right? But of course, Justice Brennan did write for the court in Baker, and his view was very different from the Erie view. His view is that the court has an important role, a robust role, in articulating, in fashioning, and protecting constitutional norms. Okay, so those are sort of the competing views. Now, Justice Frankfurter's view, I think, is on its own terms a bit naive. That is, Justice Frankfurter didn't recognize what I think was perhaps an even thicker political thicket. Right? The political questions doctrine that Justice Frankfurter wanted to decide the case on the basis of is itself a political thicket. What is a political question? What isn't a political question? That itself involves a very delicate political determination. Okay? And so even if the court had followed Justice Frankfurter's advice, it would have been making itself a potentially very contentious political judgment. And to illustrate the nature of that sort of judgment, I think it's helpful to talk a bit about the political questions case that the court is going to hear on Monday, MBZ versus Clinton. That case involves a statute wherein Congress has given individuals a right, okay? And the right is that if you're a citizen abroad and you have a child born in Jerusalem, Israel, then you have a right to have the foreign birth certificate designate that your child was born in Jerusalem, Israel. Foreign policy has for some years dictated that the foreign birth certificate would simply say Jerusalem without mentioning what country, so that the United States can stay sort of neutral, agnostic on the question of Jerusalem's status, right, within the greater sort of Israeli-Palestinian conflict. So Congress passed this statute giving individuals a right to determine whether or not their foreign birth certificate for their children would designate Jerusalem, Israel, and further specified that no money might be spent to issue any other foreign birth certificate. Okay. The case then raises several questions. One is, who has the recognition power? Does the president have exclusive recognition power? Another is, if the president has exclusive recognition power, does that extend to recognizing the territory of sovereigns, or just who is the sovereign? Right. And then, if the president has the recognition power, including power to make determinations about territory, does Congress's authority to regulate naturalization and to attach riders to its appropriations justify its regulation with respect to foreign birth certificates? The D.C. Circuit, in deciding this case, said the case presented a political question. The D.C. Circuit is certainly wrong about that, right? The question of whether to recognize that Jerusalem is or is not within Israel is a political question. That's not the question posed in the case. The question posed in the case is which branch of government gets to make that decision, which is itself a matter of constitutional interpretation, a legal question, not a political question. Okay? And I think it's pretty clear that the Supreme Court took the case in order to reverse the D.C. Circuit on that point, say it's not a political question, right? And then further, for whatever it's worth, to say that the president has recognition power and Congress's law is unconstitutional. But to me, what's salient about MBZ versus Clinton is what the district court did with the case, because I think it reflects the reflexes, the instincts of judges, that questions relating to military and foreign affairs are political questions that the courts shouldn't get involved in answering. And they will then reach for the political questions doctrine, even in cases like MBZ versus Clinton, where the political questions doctrine really isn't implicated. And I think this is pernicious, especially as it applies to war powers. Okay? And now, questions of war powers, like the question involved in MBZ versus Clinton, they can involve political questions. So the question of whether we should go to war with Iran or whether we should go to war with Libya, those are political questions. The court has no business answering that question. But other questions relating to the war power, the allocation of war power between the president and Congress, that's a legal question, right? Does the president have to receive a declaration or some other authorization before launching a war, right? That's a legal question, right? And some recent administrations have taken a view different from the standard view that an authorization is required, right? That's a legal question, not a political question. The consequence of the judiciary's reluctance to consider these legal questions relating to the president's war power is that they're following the Erie Frankfurter approach to the judicial role rather than the role that Baker versus Carr sketched out for the judiciary. And that's, I think, pernicious because of recent developments, right? The immediate consequence of that is that the executive branch is left to its own devices to interpret its war powers, right? Because who's going to second guess them? And that's pernicious because of developments over the last approximately 10 years, right? First, in the Bush administration, we had the notorious torture memo. We had a lesser noted but equally controversial opinion or contestable opinion taking the position that the president could launch a war without any authorization from Congress in advance. Okay, that's not the standard model view. It's not the traditional view even of the executive branch. Now you might say, well, we can cabin those opinions because that's just one administration that was sort of viewing its power as being on steroids, in part because of the context of the situation post 9/11. And in fact, even the Bush administration itself eventually withdrew those opinions. Okay? But I think that argument is no longer available because of the legal interpretations of the Obama administration, the frankly scandalous legal interpretations of the Obama administration with respect to the war in Libya, right? And let's call it what it is, right? So there are two legal interpretations from the Obama administration that are particularly problematic, right? First was the opinion of the Office of Legal Counsel that the president could order the use of military force, right, to enforce a no-fly zone in Libya without receiving advance approval from Congress. And you read through that opinion, and it is broad beyond anything that precedents from the executive branch would authorize, right? The typical view is that the president may order the use of force abroad that's short of war if vital U.S. interests are at stake, and those vital U.S. interests have to be a threat to U.S. persons, right? Lives or grave injury, a threat to U.S. property, or a threat to the territory of the United States. And overwhelmingly, that's what has justified uses of force abroad short of war based on the president's own unilateral authority without an advance authorization from Congress. None of those justifications was present in the Libya situation. That's not to say it was wrong to go into Libya, that Congress shouldn't have authorized the president to do it, but the president needed some advance authorization from Congress. Okay? That position, that's my position, that's contestable. Right? I will concede that. But then the War Powers Resolution required that within 60 days the president cease hostilities unless the president first received authorization from Congress, which the president did not receive. Okay? This is less controversial, although I can't say there aren't people who stand up for the administration. Right? The administration took the view that the War Powers Resolution did not apply to our involvement in Libya because, I don't know how you can say this, but our involvement in Libya was not hostilities. Right? Bombing another country, evidently, is not hostilities if you do it with a drone. Okay? What's particularly scandalous about that opinion is that it wasn't issued by the office in the Justice Department, the Office of Legal Counsel, that's supposed to issue those kinds of opinions. And the reason it wasn't issued by the Office of Legal Counsel is that the Office of Legal Counsel knew that what we were doing represented hostilities within the meaning of the War Powers Resolution. So what did the president do? He shopped around among the lawyers in the executive branch, right? The Defense Department said, no, this is hostilities within the War Powers Resolution. But over in the State Department, the legal advisor, Harold Coe, was only too happy to provide a legal justification for our involvement in Libya and to say, no, these were not hostilities, and the War Powers Resolution does not apply. Therefore, we don't have to stop and comply with the War Powers Resolution. This then is a legacy of Baker in the following sense. If the courts were willing to hear these kinds of cases, it would be very difficult, in fact, I think practically impossible, for the president to simply shop within the administration for the legal fig leaf the president seeks to do whatever it is he wants to do, right? So in other words, in order really to promote rule of law values, it would be salutary to have judicial review available, not because of what the judiciary would say, but because of the way it would improve the internal executive branch legal interpretations, right? And this is something I think Congress could easily provide for, right? The courts currently have this reflex, this instinct, to avoid questions about military and foreign affairs wherever they can, okay? But if there were a statute that clearly required the court to exercise its jurisdiction, then I think the court couldn't avoid it, right? So the War Powers Resolution is on the books, but how does it get enforced, right? Congress would need to provide someone with standing. I'm happy to talk about that during the Q&A period. I think that can be easily done. And then the other question would be whether or not what constitutes hostilities is a political question. And I don't think it is, and I hope, in fact, I expect that one consequence of the case argued on Monday is that that will be all the clearer. Although we shouldn't need that case. If we just look at Baker versus Carr itself, Justice Brennan recognizes that, in fact, questions of military and foreign affairs are not so frequently political questions as courts tend to imagine, right? That's, in fact, the first category of cases he talks about. If you go back and look at our legal history, the Supreme Court decided a number of cases relating to the quasi-war with France and didn't regard any of those cases as presenting political questions. In fact, in Little versus Bareem, in Bass versus Tingey, in Talbot versus Seaman, the Supreme Court construed the scope of the president's power under authorizations from Congress and held that certain actions authorized by the president were beyond that scope. So clearly the court has not regarded those kinds of questions as political questions, and it would benefit the Republic greatly if they would return to that position. Thank you.
Well, we have covered an enormous amount of ground in this session, and I want to invite questions or comments from folks. Again, let's come on down to the mic so that we can get picked up.
Hi, thank you for that. As someone who's working in the midst of state apportionment still going on and congressional districting here in Ohio, the most important state in the country, I am interested in some predictions if you're willing to provide them. I'm wondering specifically how the huge improvements in technology and the speed with which we can draw maps will perhaps decrease court's deference to legislative bodies as litigation works its way through. And secondly, does the perception that this process was handed back to the public further, decrease deference to legislative bodies? Because I don't think the legislature, at least here in Ohio, perceived that the process was handed back to the public. They held on to it very firmly. But if you could comment on that, I'd appreciate it.
Well, we did, for a previous paper, look at the incidence of court-ordered plans versus special master plans, and you can see an increase in the special master approach by the courts starting in the 1990s. And so that seems to be concurrent with the adoption of technology that would allow the courts to draw their own plans, which makes a lot of sense. That prior to that time, the courts didn't have the capability of hiring a special master that could actually execute and draw their own plans. So certainly the technology has enabled courts to take the lead in drawing plans instead of selecting among those that were produced during the legislative process. It's one reason why political parties and incumbents are so fearful of the courts now, because the plans that are produced by the courts may be dramatically different and not embody any of the sort of goals that the politicians may seek. So, you want to handle the other one?
Well, I'll have two comments on the first and one on the second. As Michael mentioned in his talk, in Minnesota, publicly drawn plans have been accepted for the first time. So that's an indication that the courts are paying attention to this. It's hard to predict what will happen in the future, but given some of the previous cases in which plans were compared to each other, and parties often say, well, we would have liked to do X, Y, and Z, but we couldn't. We did, this was as competitive as we could make it while holding with these other criteria and lacking evidence to the contrary. The courts will certainly defer to that. However, when there are 100 or 1,000 plans to choose from that are drawn to legal criteria, were put in the public record prior to the adoption of the plan, and would show that there are actually different sort of trade-offs available, that sort of argument is closed off. Not other sorts of deferential arguments, but the argument that there were no other possibilities was closed off, which you often see. As far as it being handed off to the public, it's not. There's a whole ladder of participation, going from people being interested in things to commenting, and then to trying to put pressure in, and to proposing alternative solutions, to consultative government. We're not nearly a consultative government yet, but we have offered people the ability to both comment in a more systematic way and to propose viable alternatives, which is increasing amounts of participation.
Thank you. I was just thinking with Candace's comment about the judge who made the kind of silly comment about hackers not wanting to go after elections because they're not valuable. I was wondering if, you thought judges would be similarly, retro in their views. Thank you.
I have a question for Neil.
I was hoping you would.
Toward the end of your talk, you said that you thought that one of the legacies of Baker was Obama's ability, or any president's ability to shop around and get whatever advice they wanted to get, no matter how ludicrous the proposition was legal. And I was wondering whether you think, or could you flesh out a little bit, whether you think that is a legacy of a problem in the way that Brennan wrote the part of the opinion on the political question doctrine, or is it the result of a misinterpretation, an unjustified misinterpretation of Brennan's opinion in Baker versus Carr?
Right. So that is a friendly question. Thank you. I misspoke. What I meant to say was that it's a legacy of Frankfurter's view in Baker versus Carr, that judges shouldn't intervene. And I think it's a failure of judges in the interim to sort of take seriously what Justice Brennan, I think, correctly observed in that portion of the opinion, that, in fact, questions about military and foreign affairs are not so thoroughly political questions as is typically assumed.
Thank you, and appreciate the presentations of each of you. Neil, and on that point, I guess part of what I was gathering from your presentation was that the court should play a role in some of the more political questions, like you mentioned the Libya, I don't know if I agree with the word war, but the military action. And I guess what do you see as the practical application of that? In other words, if there is a conflict between president and the Congress, where perhaps the president misused the power of the War Powers Resolution, why not just allow Congress to use its natural check in the form of the purse strings of the government, as opposed to intervening, having the courts intervene, whether it's some hybrid temporary restraining order after the commencement of a military action? Why not simply allow the natural political question to take place in the form of congressional withholding of appropriations for military action?
Because that doesn't work. It hasn't worked. The framers knew that wouldn't work either. That's why they limited appropriations for the military to 2 years, so they would expire. But the president can find money to do this, right? So Congress didn't appropriate money to go and enforce a no-fly zone in Libya. That money is in the Defense Department budget. Once we start a military operation, it's virtually impossible as a practical matter to defund it, right? So if there's going to be an effective constraint, it's not likely going to come from pulling the purse strings, right? And in fact, the Constitution doesn't limit Congress to the purse strings. Congress has a long list of military powers, not just the power to declare war, but the power to provide rules and regulations for the land and naval forces, to raise and support armies, to identify and provide for violations of the law of nations, right? And it goes on, the list of congressional war powers. So Congress isn't limited to just using the appropriations power. It can directly regulate what is done in the context of a war, as long as it doesn't go so far as to violate the president's commander-in-chief power, and that's often controversial, right? But Congress has affirmative regulatory powers. It's much more effective and efficient for Congress, and in fact viable for Congress, to use those powers to limit the president as commander-in-chief. And in fact, the Constitution's design appears to be one that assumes that that's what they will do, right? Not to just rely on using the spending power to limit the president.
I see your point, but it seems to me that in all the other contexts and some of the presentations we heard today, it seems like the courts have taken the reactive role when it comes to redistricting, when it comes to a host of other issues. And in this instance, I hear your argument to say the court should be proactive, almost in a policy-making role, in that while Congress has these other options available, maybe not simply the purse strings, but the other options it would have available simply may not be politically viable at the time. But the courts, in how you have suggested, would be letting Congress off the hook of maybe less politically viable options by invoking itself into some, whether it's a political issue or whether it's a foreign policy issue. But
Right.
It doesn't seem like, from a practical standpoint, we would want the Supreme Court or even a district court, whether it's from the DC circuit or wherever it would come out of, make certain decisions that would preempt what the presidential powers are. Seems like the after the fact, the more reactive role that the courts have taken would be the proper role.
Right, and
In your
that's what I'm.
the scandalous right, the scandalous example that you.
Right, and so the court's role would be reactive, right? Someone has to go to court, and that would happen presumably after hostilities have occurred for 60 days, right? If there were an enforcement mechanism for the War Powers Resolution, the judiciary would get involved in that at that point. The proactive consequence of judicial involvement doesn't itself flow directly from the judiciary. The fact that the judiciary could get involved later will mean that before the president acts, the president and the president's legal advisors are going to have to take the demands of law very seriously. So the president doesn't announce that what we're doing in Libya isn't hostilities, because he knows that if that goes into court, right, he's going to be made to look like a fool.
We'll agree to disagree.
Okay?
But I appreciate your comments.
Okay?
I have a comment and also a question, mostly directed at Margot, but I know that that Michael and Mika also have a lot of expertise and may want to chime in as well. But the census data are wonderful with all the warts that they have that we know about. But one of the issues for the redistricting data that's required for redistricting, is that they don't include current and good precinct geography, for which you can then produce the data that's necessary to evaluate, competitiveness, et cetera. The process is one, for those who don't know, that where they do collect from the states information about the boundaries of precincts where the election results are reported, but it's done in so early in the process that you have to use only the 2008 geography of the precincts, for example, and the issuance of the final geography, the Tiger files for the process comes really late in the process, and so it makes it very difficult to come up with good, accurate data for doing redistricting. I've heard from somebody that there's actually discussion, maybe even a pilot project or development of something at Census, in which they would try to automate the process of adding the precinct geography to their Tiger file in a much more current, up-to-date kind of way. I don't know if you've heard that as well, but I'm curious as whether or not that's in the works.
Yeah, I don't know, and I would send you to the geography division, because I wouldn't want to say, but the point that you're making about the disconnect between the electoral geography and basically what I called enumeration or collection geography is a really important one. And it's actually the legacy of the 1920s lack of apportionment, because for 40 years between the 20s, this is in the paper, it's not, I didn't talk about it today, but for 40 years, the Bureau was freed up, if you will, from having anybody from any political branch ever ask them to align their geography with any electoral geography. Lots of other people did come at them, mostly cities and local areas that wanted health districts and census tracts, and so the small area data tabulations that they developed between the 20s and the 60s don't measure don't measure electoral geography. And that's what became quite obvious in 1970 when the state legislatures and the state data officials began to take a look at what they were likely to get after the 1970 census and threw up their hands in despair. Right. So the Census Bureau is very unhappy about undoing all their geography, because of course mapping 8.25 million blocks is no mean task, right? They do use it for collection, so that the problem I see is actually a very deep and fundamental one about the sort of intergovernmental relations and who gets to tell what to whom, right? Which is why Congress finally had to come in and pass PL 94-171, which clarified who had the responsibility to set standards, when, and why. And it's still an ongoing process. Now, it has gotten much, much easier as the technology has developed. But there are, if you go into the Census Bureau, they still don't necessarily see the PL requirements as their main task, right? Because that's just one file. And in fact, because it needs to be dumped out so quickly after the census, they sort of get it out the door, and then it becomes a kind of orphan, and they move into what I call the summary files. So SF1, SF2. If you're a census junkie, you know about this stuff. And they never, they don't look back, if you will. Data's out there, whatever, right?
So what's the use of having the precinct boundaries delineated in census geography? There's two purposes. One we've already been talking about is be able to value the political consequences of a redistricting plan. The other purpose is to do voting rights analyses. And so that's very important, especially in Section 5 covered jurisdictions, but elsewhere too, as to why you would do this. Now, we identified through our work in our advisory board that one of the reasons why a jurisdiction may not decide to participate in phase 2 of the redistricting data program, which is when these boundaries are transmitted to the Census Bureau for incorporation into the census geography, is that they don't want people to be able to evaluate independently the political consequences of the redistricting plans. And so I've, for example, been talking with Janice Thompson, who's the Common Cause person in Oregon, and she's very frustrated that Oregon did not participate in phase 2, and the people in the politicians in Oregon really have no interest in ever doing that, because they hire an outside consultant to collect these boundaries and overlay them onto the census geography, and they're able to do their partisan gerrymandering without any oversight from the public. So I would like for all states to participate. Now, some states, if we're thinking about best practices or how to get these data so that they're usable, not just for the long term of maybe 2008, 2010. Some states, once they draw the boundaries, they are static throughout the entire decade. Some states, once they're transmitted to the Census Bureau for incorporation into the census geography, they are frozen in place at that point in time until after the redistricting happens. And then there are other states that don't transmit their boundaries correctly, that don't transmit them at all, or change their boundaries even between the time that they're transmitted and the 2008 election. So it becomes a big headache when you're working with these data, and there's a lot of error that's involved in it as well. I think if there was going to be a best practice for Ohio, because Ohio is not one of the states that really participates with phase 2, would be that sort of state where that scenario where you transmit the boundaries and then freeze them until after the census, after the redistricting is done.
Also add that just on top of that, just because the boundaries exist doesn't mean that the electoral data connected to it are easy to get to.
That's true too.
A question about Ohio. Mike, if I'm not mistaken, it was either you or Justin Levitt mentioned to me a couple years ago, please correct me, that the way Ohio has structured its creation of the state senates, the state senate, it basically insulates one political party in control of the state senate. And I'm wondering if I understood correctly, and if so, I'm wondering about whether there's any legal remedy available outside the legislative remedy if truly by law, by the operation of law, we've just instituted one party control over one house of our state legislature.
Right, so Ohio has one of the most elaborate geographic criteria for state legislative redistricting in the country. There's a hierarchy of geographies that can be split and it starts all the way down at the ward and precinct level and works its all the way up through townships and counties, et cetera. And those splits have to be minimized in a certain mechanical fashion as well. And so as part of a Joyce-funded project over the decade, I had mappers drawing districts in Ohio and elsewhere in the Midwest. And we were finding some of what Micah was mentioning earlier about how the geographic distribution of Democrats concentrated in urban areas works against them in terms of redistricting, if you're going to draw compact districts, for example. Not always. And there's another project that Jonathan Rodden from Stanford, who's also finding a similar finding as well. So, and this goes back to the 1970s at least, that this is conventional wisdom in geographers and political science. So, but I challenged my mappers at one point to follow, not even closely, strictly follow the Ohio criteria. So I even gave them a little bit more leeway to draw a partisan Democratic gerrymander following the state constitutional criteria in Ohio. And they couldn't produce a Democratic favored map. Now this was with 2000 data, and I understand that, though I've never seen the analysis, that was verified by the National Democratic Party as well. So there was an opportunity for the Democrats to have some sort of bipartisan effort to reform the process for state legislative redistricting in Ohio. And at the time, Democrats thought that, well, they were going to control the apportionment board and that was going to be enough for them. And I tried to warn people that even if control is not going to be enough, sufficient, but you know, nonetheless, they thought that the control was going to be enough. And of course, that control didn't persist after the 2010 election. And so, you know, they missed the boat, in my estimation. They got a little greedy and are paying the consequences of that. With the latest apportionment board, of course, we're likely going to see legal challenges to it, speaking of which.
So, yeah, our state constitution is really a mess when it comes to drawing state legislative districts. It's actually impossible to comply with all of the requirements of the Ohio Constitution. My question is actually for the other Michael. Three-judge courts. So I actually have a couple questions. First is on the issue of why we have them at all. I mean, it seems to me one of the things this does is puts a lot of pressure on the gets it up to the Supreme Court more quickly and puts a lot of pressure on the Supreme Court to issue a published opinion. They can, of course, summarily affirm, but that has precedential effect. So if they want to say something different from what the three-judge court says, there's a lot of pressure on them to do so. So I'd love your thoughts on that. The second question is, boy, what seems most problematic about this to me is the ability of the chief judge to stack the panel. And it seems like there's also a really easy legislative fix for that. Just require that all three of the judges be chosen by lot. And it you know, it's the kind of thing that might actually might be agreeable to people of both Democrats and Republicans in Congress. So has that been proposed, and is there any chance of something like that getting anywhere?
Okay. On the first one, not to get too technical here, but first of all, just for whatever it's worth, just statistically, over the long life of the three-judge district court from 1910 to the present, even in its limited version from 1976 to the present, I think I'm fair to say most of the direct appeals, and of course not every three-judge district court decision, it has to be appealed, right? It's, and probably most aren't, but those that are appealed, there's a direct appeal to the Supreme Court, and I think just most of them are in fact summarily affirmed. There's an important election Voting Rights Act case, Cox versus Larios, I think it's called, that was summarily affirmed in 2003 or something like that. But some are, decided by full opinions on the merits.
There's a much higher percentage than circle, right?
Yeah, granted. I mean, the vast majority of cert petitions are denied. But to answer your question, my understanding is that the summary affirmance does have precedential effect, but only for that case. It doesn't bless the reasoning of the district court, whatever it may be, for the rest of the country. It only has precedential effect for that, a kind of law of the case sort of thing for that particular case. That's my understanding. The Supreme Court itself has said that in other cases. So on the second point about the possibility of panel, stacking, which, should be worrisome for those of you who perhaps are less, are more, worried about the partisan / political decision making by federal judges. I just reiterate that the evidence, at least the way I see it, shows that that's not, being done in these. It's not, there's not a lot of hardcore evidence that chief judges are stacking these 3-judge panels and reapportionment, or even pre-reapportionment, pre-1976 cases. Either, but that's something worthy of further study. But to the extent that's a problem, as you say, sure, I mean, there could be a legislative fix. I agree that the 3-judge district court statute simply could be amended to provide for, random assembly of the judges, like is done for, just any case you file in federal court with a single district judge. That at least within that district, there's a random assignment of the case to any given federal district judge in the district, and kind of in a parallel fashion, you could do that, to assemble a 3-judge district court, and you could take it entirely out of the hands of the chief judge. I'll just mention real quick one further point to that. I'm thinking more of of some of the commentary, and especially in the 1970s, that led up to the restriction of the 3-judge district court to reapportionment cases. I'm reminded, actually, Judge Henry Friendly talked about this, and others did too. Some of them said that they're actually that the 3-judge district court actually the statute should mandate that there be federal judges from different political parties. It'd be a problem of exactly how you measure that. I mean, would it be self-identification? Would it be the party of the appointing president? That would be problematic to do that. But to deliberately make it kind of bipartisan, I guess, if that's the right word, and that's sort of almost the opposite. Maybe not quite the opposite, but quite a different idea than you just presented. And I'm not saying that's a good idea, but that's that was discussed. But I don't think there's been a formal proposal to do what you said. But it's something to think about.
Okay, we have time for one more quick question.
Well, I just can't let it go unsaid that there were several redistricting reform proposals in the last General Assembly here in Ohio. And the one that it gets talked about the most still today ended up, the Ohio Supreme Court would be the one who would be the final decision maker if there was gridlock. And the Ohio Supreme Court, of course, being mostly Republican, I think all Republican at the time, and shown to have acted in partisan ways in the past. So, there's a lot of blame to go around for that not happening. It's unfortunate that it didn't happen, but I just had to get that in there. Thanks.
Okay, well, we have covered a huge amount of ground this afternoon and all day. I think the first thing we're going to do is give a round of applause to this panel. Not all of our speakers have been able to remain for the day, but I think we should give one last round of applause to all of our speakers. And I'm going to exercise the prerogative of closing things up But before I do that, there are some folks who need to get recognized, not the least of whom are Jared Gregory, who's up in the corner, Alice Simon back there, and where's Nancy? Okay, and Nancy Pratt, our academic centers folks who did all of the heavy lifting to make the details of this program work with our out-of-town speakers, made the arrangements for accommodations for dinner and food. So thanks to them. And finally, in my role as faculty advisor to the Law Review, I want to thank the Law Review editors and staff for doing such a terrific job here, and I want to single out two people in particular. One is John Murray, the editor-in-chief. And last but by no means least is Andrea Lee, who has just been a tower of strength through all of this from the time that we first started talking about doing any kind of symposium. This would never have happened without Andrea, so thank you. And with that, we're adjourned, and feel free to continue the conversation for as long as we can keep going.